everyone, and welcome to today's program, Denaturalization Demystified, a practical guide for immigration attorneys. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I am absolutely delighted to introduce our speakers, Nancy Canter and Lindsay Vick. Nancy is an experienced litigator and advisor at Gordon Rees, where she leverages her extensive career experience at the Department of Justice in Washington, D.C., to guide clients through complex regulatory challenges, administrative law matters, constitutional claims, and all aspects of commercial contract disputes and civil litigation. Nancy is experienced in both employment-based and family-based immigration matters, as well as workplace compliance. She advises on governmental investigations relating to compliance with U.S. immigration laws, including worksite enforcement actions and raids, immigration compliance audits, H-1B site visits, civil denaturalization, and responding to administrative and judicial warrants. Lindsay Vick is also a litigator at Gordon Rees, where her practice encompasses class action defense, administrative law, constitutional claims, and civil litigation. Her immigration expertise spans removal defense, habeas corpus petitions, citizenship, and civil denaturalization. Prior to joining Gordon Rees, Lindsay was a senior litigation counsel with the U.S. Department of Justice, where she focused on immigration-related federal civil litigation in federal district courts and circuit courts appeals nationwide. She advised senior leadership at the Department of Justice, Department of Homeland Security, Department of State, and Department of Health and Human Services on complex legal and policy matters. We're so excited to have these experienced speakers with us today, so I'm going to turn it over to them.
Thanks, Ala. It's good to be here. Let me get our screen share going. So we're here today to talk about civil denaturalization. I know it's been kind of a hot topic and an interesting topic because it's been in the news a lot. One of the things that we're going to focus on is kind of not just the recent case trends and the recent rhetoric about ramping up civil denaturalization, but also kind of the nuts and bolts and the procedures for how the government initiates these types of actions and what we've seen traditionally in terms of how they're prosecuted.
Great, and thank you, Nancy, for that introduction. I will preface this by saying that I am unfortunately not in sunny California. I am in sunny Atlanta, Georgia, but it is also high pollen season. And so if I'm coughing or sneezing, please excuse me. I'm not sick, I'm just suffering from allergies. Okay, that out of the way. So the profile of a typical civil denaturalization defendant. Who are we talking about? Who are we expecting to see the government ramp up resources and taxpayer dollars to denaturalize? These cases are not always what you'd expect from an action as severe and serious as stripping someone of their citizenship. Defendants in these cases are generally not the worst of the worst, although as with all things, there are exceptions. There have of course been denaturalizations of terrorists and child abusers. But thankfully, those people are not all that common. Instead, the case of Norma Borgono, who you see pictured here, is fairly typical based on the cases that at least I have seen when I was at DOJ and since that time. Borgono was elderly, she was a grandmother, or is a grandmother. Presumably, she is still alive. I don't know where she is today, but speaking of her in the past tense. She was elderly, she is a grandmother, and she wasn't some well-known fraudster who famously made off with millions. She actually didn't even profit based on her criminal activity and did cooperate with the FBI during her criminal proceedings. However, she was still denaturalized. And so when the government says that it's going to be ramping up denaturalizations, it's important to understand that these, the majority of the time, are going to be people who are older for several reasons. Naturalization is typically the end of a person's immigration journey, and that journey alone can take years. So those who naturalize are often older. And also, the criminal activity forming the basis for denaturalization is necessarily discovered after naturalization, or else the person likely would not have been naturalized in the first place. So then that depends on how far back the government goes in its investigations to find denaturalization defendants, and that will determine how much older these defendants are. So a lot of the time you're dealing with people who have adult children, grandchildren, health issues, not a lot of money, fixed incomes, they're retired. But discretion and equities do not come into play in civil denaturalization. If most defendants are older and not wealthy, they don't have the money to litigate what can become quite expensive civil case for the average person. And moreover, the government is not necessarily exercising prosecutorial discretion, especially now under the current administration, based on sympathy or equities. These cases are driven by statutory compliance. And so if you don't manage to reach a pre-litigation settlement, then discretion and equities just don't come into play. And I'll hand it off to Nancy.
So, I think one of the reasons certainly that I've seen for this uptick in interest in denaturalization is, the rhetoric, both during the first Trump administration, but especially during this most recent new administration, that, they're going to have an annual or a monthly target of 100 to 200 referrals. That's caused a significant amount of concern, not only among immigration practitioners, but also just friends. I have a lot of friends, and I myself am a naturalized US citizen. So I have a lot of friends who are naturalized US citizens or have family members who are, and there's been a significant concern that, when you start looking at numbers ranging in 1 to 200 a month, who are they going after? What is happening? Historically, between 1990 and 2017, the government filed about 11 on average per year. That's 11 of these actions filed in federal courts. When the government is now saying that they have a monthly target of 1 to 200, you'll notice that number refers to referrals, not case filings. I think it was on an X tweet or some kind of press blurb that I saw a couple weeks ago where the Attorney General Bondi said that in the first year of the Trump administration, they filed 40, I believe, approximately 40 denaturalization lawsuits. That is a significant increase from what the government has historically done. If you're looking at 11 average per year, obviously that's 4 times as many. However, that's still a far cry from the 1 to 200 referrals. And we'll get into kind of the difference between, when a referral turns into an actual lawsuit. So the government loves civil denaturalization for many reasons. 2 of them are because it's a lower burden of proof. There is criminal denaturalization. We're not talking about that today. There's a slightly higher burden of proof for criminal denaturalization, and there's also a time limit. I believe it's 10 years. There is no time limit on civil denaturalization. You can have become you could have naturalized and become a US citizen, 30 years ago, and the government cannot come and say they're going to denaturalize you now. The other reason is there is no right to legal representation. Unlike in criminal proceedings, you're on your own. You can represent yourself pro se. Obviously, I don't recommend it, but there is no right to free counsel. So individuals are often left with a choice of, kind of where and how are they going to get the resources, and who are they going to have to defend them? Again, historically, civil denaturalization is not a big thing. So there aren't that many folks in terms of the immigration bar or just generally who are aware of how to defend these types of cases. So this prioritization that the department has kind of made one of the hallmarks of this administration is per a June 11, 2025 memo to instruct attorneys to maximally pursue, that's the language used, all cases permitted by law, specifically targeting organized crime and financial fraud. And I will say that, what the big examples of cases that I've seen so far that have been filed and the ones in which denaturalization has been successful have largely been cases involving some kind of financial fraud or criminal conviction. And we'll cover why those are kind of the easy ones for the government to come to their attention. So this is statute-based. And one of the reasons why I love civil denaturalization is because it's statute based. It's actually in the code. It is not in the regs. It is not a policy. It is in the US code. And denaturalization occurs when DOJ establishes that citizenship was procured by concealment of material fact or by willful misrepresentation or was illegally procured. Concealment of material fact or willful misrepresentation. That's where you get into problems, because failing to disclose a material fact that would have affected the government's decision to grant citizenship is a basis for denaturalization. For all the lawyers out there, you can see there's no scienter requirement. There's no intent to deceive, intent to commit fraud, intent to deceive, intent to like omit. And we'll get into, as we look at kind of various circumstances in which I've seen civil denaturalization referrals come into play. So when you are looking at a denaturalization case, the very first thing that the government is going to look at is your Form N-400. And the N-400 is your application for citizenship. It is not I don't think it's a particularly complicated form, but I think that's because we're lawyers and we filled out the bar character form so many times in the course of our lives that we're used to it. But when you look at the N-400, it asks for very detailed information. And there are, not only do they ask for resident history, but there are also many categories which can be more inclusive than an average normal person thinks or would necessarily come to mind when filling out this form. As I've been, kind of working in the denaturalization space, or, I spent 2 years briefly at USCIS working with the affirmative litigation law department, where we looked and where we reviewed referrals before they went to the Department of Justice. It was really kind of shocking, the kinds of things that the application asks for and how little the average person understands in terms of what they need to disclose. So for instance, on the bottom right, omissions about marital status or residence can trigger fraud claims. Misrepresentations during the green card stage can impact your naturalization. So I definitely saw instances where an individual got married, got the marriage annulled. The N-400 asks, disclose all your prior marriages. Is that annulment a marriage that needs to be disclosed on the N-400? I would say yes, but I don't know that necessarily everyone would think that, or that the average person would consider that something that needs to be disclosed. We also had many instances, and probably in some cases the most tragic ones, was the accuracy in disclosing prior removal orders. My favorite example of kind of just how unwittingly someone can find themselves in a civil denaturalization situation is the example of an individual who came to the United States in the 90s and applied for asylum in New York. A lot of people applying for asylum in New York, nothing was digitized. At some point, this person moved from New York to California, and they applied for asylum again. They ultimately got asylum. They ultimately, became an LPR. They ultimately became a US citizen. Many, many years later, our records are now digitized, and the government has discovered that actually when this individual applied for asylum in New York, they moved and did not update their address, and that a interview for an asylum application had gone out, or an interview notice for the asylum application interview had gone out. They had failed to show, and an order to show cause had issued. As a result of that, he was issued an in absentia removal order. So he does have a outstanding removal order that's in absentia that this individual has never known about. He would have had no way of knowing about it. He never updated his address. USCIS has no duty to go find you and make sure you're aware of it. But when he applied for that, certainly when he applied for his N-400 and became a naturalized citizen, he was asked whether or not there were any outstanding removal orders. And when they said no, that was false. And that is a basis for the government to seek denaturalization. And I saw many, many cases during the course of my time at USCIS where that was essentially the fact pattern. So we're going to go, this is one of the big questions too. On the N400, it asks, have you ever committed a crime for which you were not arrested? So I love this one because have you ever committed a crime for which you were not arrested? Well, I mean, I was 4 years old and I took a pack of gum at the store. Is that a crime? I wasn't arrested for it. I've given variations of this talk multiple times to many folks. And, the question is, well, is that a crime within the US or is that a crime abroad? What if I got a speeding ticket when I was driving in Denmark? And then, and I mean, there's just a lot of what ifs that nobody knows the answer to. Many reported denaturalizations are based on a false no answer to that question by naturalized citizens who committed these crimes or crimes that they were not arrested for. It's difficult because when you're filling out that form, you really have kind of no limits as to what you can or should disclose. And let's be honest, I'm not sure that everybody would even be able to pull these records. I've played this game before myself where I thought, well, I mean, is all my speeding, is all the times I sped or maybe didn't fully stop, would that be considered a crime? We just don't know. I want to take an opportunity to pause here and ask Lindsay if you have anything to contribute or if you want to chime in.
Oh, just that I agree. This is the question. It's the hook that I think gets everybody and by surprise, because I think a lot of people, when they're filling out the N400, they look at this question and they just think it's silly. And they're like, oh, silly government. Why did they put it there? It's just the government and being bureaucratic and adding more words when it doesn't have to. But actually, that question is very, very important for the exact reasons that Nancy just stated.
The question is, when does denaturalization occur? So denaturalization is typically based on pre-naturalization activities, anything that you did before you became a naturalized US citizen. But it's the failure to disclose that activity, that crime, that outstanding removal order, that prior marriage, all of that stuff at the time of your N400 that becomes an issue. I'm focusing here a lot on the N400, but because that is the one that is the most recent in time, so you'll have the most prior history to look at. But it can also be based on, failure to disclose things on your I-485 application for a lawful permanent resident status. USCIS does have available to it your entire immigration file. We call it the A file. And that A file includes copies of all of the applications the individual has filed. And it can go as far back as misrepresentations on your initial I-9 form. You came in on an I-9 and you didn't disclose something. That could be a basis for material misrepresentation or omission. It could be on your I-485, your application for asylum, and your N-400. Typically, crimes committed after naturalization do not serve as basis for denaturalization, so don't worry about that. USCIS tracks criminal proceedings of naturalized citizens and compares fingerprints of convicted individuals with naturalized citizens. So one of the things that I learned when I was with USCIS was that DHS has a Office of Biometric Identity Management. I believe that's what it stands for. It's OBIM. And OBIM is basically the federal government's repository for all of your biometrics information and data. Fingerprints, eye scans, all that good stuff. They run the database that USCIS uses, TSA uses. They link up with the FBI and share resources and information. They are the entity behind kind of how when you go through TSA and you have to show your fingerprints or have your face scanned, they are the entity behind those hits. I have long since I have long since given up any hopes of committing any crimes because my fingerprints are everywhere. But you know, USC, but the government has your fingerprints. They are digitized. And depending on who is running those prints, the results can come almost immediately. Obviously, when you're entering at the border and you know, you're trying to get through CBP or TSA, those hits are pretty fast. If you are going to an asylum interview at an asylum office and you have to go in for your biometrics, those hits are on a slower return. Those hits are on a slower return time scale. But the fact is, the government has your fingerprints. They can track them once they're in the system. They information share with local state entities and the FBI. So that's the easiest way to get a hit on someone who has a criminal activity and their citizenship. So trigger events for denaturalization are some family petition or something that is filed that causes a manual audit. I will just use myself as a example. I naturalized in the United States in sometime in the 1990s. So for example, if I were to, think of a good way of saying this, if I, you know, my file would technically, I guess, be closed, or let's use my parents as a better example. My parents would technically have a closed file. You know, their A file would be sealed somewhere at the USCIS cave where they store all the A files. If they are going to file to petition for someone to come to the United States, by doing that, USCIS will pull their A file and look at it. And when they pull their A file now in the year of 2025, they may look at things that were filed in the 1990s and previously, and that may trigger an audit. We talked about criminal investigations. If you are prosecuted for state, federal crimes, that could trigger a look at your naturalization eligibility. That's a pretty easy one too. It's just a simple fingerprint hit. And then it's a question of when you committed those crimes and when you became a naturalized citizen. And then there's database audits, the integration of biometric data across agencies. And, you know, we kind of live now in a state where we just are certainly, I just assume my information is out there. You know, there's all this talk about kind of AI and how you're scanned and, you know, processed through all these things, but it wasn't always that way. And there have been periods in our history, and I've certainly seen it in the government's history, where the integration of biometric data has triggered these audits that have led to denaturalization. The big one is Operation Janus. So historically, when you applied for citizenship or asylum, whatever immigration benefit, you had to go and get your biometrics taken. It is fingerprints. I've seen so many of these, but it's a historic fingerprint card. Anyone who's a lawyer has done it. You've gone to, you know, your local police department or done a FBI or Department of Justice background check where you've had to give your fingerprints with the four fingers and then your thumb. So those are paper cards historically, right? We didn't all have computers. We certainly didn't in the 1950s and the 60s and the 70s and 80s. So they were all printed manually on a card. And I remember going to the police department in the 90s when we needed to be my family needed to be fingerprinted for our naturalization. Those fingerprint records were digitized at some point. There was actually an effort to scan in all of that biometric information that existed on paper fingerprint cards and load them into federal databases. That was what resulted, or I think that was Op Janus, which was the effort to integrate and digitize all these fingerprint cards. What happened was that, well, you digitized all these fingerprints and you realized that you were getting hits. You were getting somebody, in the example that I gave at the beginning, somebody who had applied for naturalization or applied for asylum in New York in the 90s, then 8 years later applied in California, never disclosed that they had previously applied for asylum or that they had an outstanding removal order they were not aware of. That Op Janus at the end of the at the end of the Obama administration, there was a inspector general report that basically directed the government to sort out kind of this apparent conflict, right? Like, why do we have all these paper identities that are matched hits with kind of our federal, digital database? What is going on? Figure it out. So that really was, it was the end of the Obama administration, start of the first Trump administration, where Op Janis led to that inspector general directive to figure out, what was going on. So during the first Trump administration, USCIS and the Department of Justice actually stood up specific immigration, naturalization, or I should say affirmative litigation units to identify, investigate, and refer these cases for prosecution. What happens is that USCIS is responsible for doing the initial file review. So they will pull the A files, they will assess the prior application, the existing application, and you will literally have, USCIS will literally have an individual's A file under one application or identity and the individual's other A file under another application or identity. They will look for matches, they will look for conflicts, they will look for any kinds of issues. They will also, because our records are all digitized now, they can also actually look at this individual's entire travel history. They can also see kind of what has happened in terms of if there's been any state activity, federal activity, kind of, your entire history is out there. We would get basically CBP travel reports from our DHS investigators that basically had every entry and exit in and out of the country, the dates and the times of those, and kind of the fingerprint identification number that matched the applications. So we could, in some instances, have cases where an individual has a 1990 paper application, they have an early 2000 they have an early 2000 file under which they ultimately naturalized. And then I've had cases where, I can look at this individual's entire travel history and kind of match when they may have traveled here or there. Again, there were so many instances where it was an unsuspecting individual who applied in New York, moved to California, never knew he had an outstanding removal order. But we also had cases where people were traveling under false identities. And it was that, it was very obvious when that was the case, right? Because you'd have one application where they had one named Bob, and then they had another application where they had another named Joe. But you could have at the same time their entire travel history where their fingerprint identification numbers match, they're coming in and out. And, certainly as we get into the 90s and the 2000s, you could then start having actual picture images of the snapshot that CBP captures when you're coming in and out of any port of entry. So it was kind of like putting together a puzzle. Once you put together that puzzle, or USCIS is responsible for putting together that puzzle, and that is what turns into the referral. So we mentioned earlier the 1 to 200 cases for referral. That is the packet that USCIS, the agency, sends to the Department of Justice saying, this case, we have the evidentiary support for you to proceed with denaturalizing this individual. Do you have anything you want to chime in and add, Lindsay?
Not necessarily on this slide, but thanks.
All right. In there. Right. So, what happens is, a case is referred to the Department of Justice. It's interesting. I mentioned earlier, I love DNATs because it's statute-based. There is actually a procedure that the government must follow in order to initiate these actions. And it is the U.S. Attorney's Office. It is the U.S. Attorney's Office and the U.S. Attorney who gives the final sign-off and approval to file a civil denaturalization action in his district. During the first Trump administration, there was hesitation among many U.S. attorneys' offices to file and bring these actions. I remember having many discussions with U.S. attorneys' offices who were reluctant to bring these actions or who wanted to conduct their own investigation and not rely on USCIS's investigation before proceeding. So that is, theoretically another check on another check or another stop pause before these cases are filed. They have to go through USCIS. They have to get sent to the Department of Justice, Office of Immigration Litigation in Washington. And then the U.S. Attorney's Office for the district in which the individual resides also has to sign off on the decision to file that complaint. Individuals are by statute given 60 days personal notice to answer any petition. I find that that notice section is very interesting because it uses the word notice and not service. So is the personal notice the day the U.S. attorney reaches out to the unsuspecting grandmother and says, we have evidence to believe you committed fraud in your naturalization application, and 60 days from that email or letter, she has, defaulted? Or are we actually waiting for a time period? Are we actually commencing it upon the filing of a civil suit? That's not been litigated to my knowledge, but that is something that, folks who do denaturalization should be worried about or concerned about. The burden of proof is that the government must present clear, unequivocal, and convincing evidence. It's a high burden of proof, but not really when you consider the fact that no scienter or affirmative attempt to deceive or defraud is required. Typically, these cases are, in my experience, decided on MSJ. Many of them are decided at summary judgment because they're simply, it is very hard for an individual to say, no, especially in the case of the unsuspecting grandmother who applied in, New York and moved to California. They can't say, like, the facts show you had an outstanding removal order. You didn't disclose it. We don't care that you didn't know about it. That's not our problem. The fact is that you had one and you did not disclose it, and that's a problem. Typically, I would say in these cases, you could expect to do some discovery and some depositions. And then, if and when an individual is denaturalized, the court will issue an order revoking citizenship and canceling the certificate. Now, I know, Lindsay, this one you probably have something to add and contribute to, so I'll give you some opportunity to do so.
Sure. Yeah. So I've seen cases where the U.S. I guess one anecdote, the U.S. Attorney's Office brought a case when I was at DOJ that I reviewed, and the U.S. Attorney's Office told me that this person was a fraudster, clear evidence of fraud, and it was a slam dunk case, and I needed to get on to filing it as soon as possible. However, when I was reviewing the record myself, I noticed that the person they were seeking to denaturalize was an older woman, not necessarily elderly, but I think she was in her 50s or so. And the person had actually a history before they came to this country. They were a victim of what I would call human trafficking. They were a minor, underage, and essentially forced into prostitution. And the government, I think at one point in her file, was saying that she was subject to a prostitution bar, but luckily, I think there was discussion and they walked that back. Either way, when I was reviewing her, I think it was an I-130, she was allegedly petitioned for by her husband, but this husband was more than 40 years older than her. And she was quite young at the time. She was overage, but still quite young. And so I think all that is to say, some of these cases, I think the investigation can actually reveal some other type of, action that the government should look into. And I think in this case, it was potentially human trafficking. However, at that point in this person's life, it had been decades since she naturalized. She, I think, was having health issues. She was a widow. And so, then you have to think, as the government, does this person really want to be involved in some type of action against her traffickers, if they're even still alive? And certainly, is this truly something that the government wants to pursue for denaturalization when the fraud may have been a result of human trafficking? So that was one of the first denaturalization cases I came into contact with. It was very interesting and eye-opening, I would say. All right. So moving on to where these cases are won or lost. We've kind of spoken about this. As we mentioned, the standard for civil denaturalization is lower than the criminal denaturalization standard, obviously. But the courts have set a higher bar for success than typical civil burden of proof of preponderance of the evidence. And I believe, and I meant to clarify this before the presentation, but so once the government meets its higher burden, I believe it's the defendant only has to show their case or rebut that evidence by a preponderance. But please correct me if I'm wrong, Nancy. I'm pretty sure I remembered that correctly. And so the government's success rate is thus closely tied to its ability to present the clear, unequivocal, convincing evidence and to comply, of course, with the statutory prerequisites. And their failures to meet the statutory prerequisites, even though they may seem just procedural, they are important and they can result in dismissal of the government's case. For example, they have to make an affidavit of good cause. And if they decide to forego that process or do it incorrectly, their case can be dismissed. And as we were mentioning, in practice, these cases are usually resolved on dispositive motions, because usually what it comes down to at the end of the day is legal arguments. Legal arguments about the various statutes involved, the denaturalization statute, if there's a statute of conviction relevant, the fraud statute. There are arguments that defense counsel can make. And actually what has happened in a lot of these cases is so the defendant will file, well, there's a complaint, defendant will file either an answer, often a motion to dismiss, and basically saying that the government hasn't made a case, and then ruling on that motion to dismiss will happen hopefully before you get into discovery, but maybe at the same time, depending on your court. And if the motion to dismiss is denied, then obviously defendant files an answer. Then what the government has done in a lot of these cases recently is they file a Rule 12C motion for judgment on the pleadings. Essentially the same or very similar to a motion for summary judgment, and basically just telling the judge, look, there's really no need for discovery here, which can be beneficial to your defendant client if you're representing a defendant here. We don't need fact investigation. This is just legal issues, and so rule on this substantive motion. And so defense counsel can argue materiality in the statute. They can try to argue mens rea. Sometimes these arguments can get really tricky, really nuanced and in the weeds. But there are some hooks for arguing that actions were not, or statements were not knowing or willful. Again, the statute does make that very, very difficult. But there are ways you can try to make those arguments. And particularly if the criminal statute is at play, there can be crimmigration arguments, and that's immigration lawyers often refer to the intersection of criminal law and immigration law as crimmigration. And so you can make these arguments as well, because the government will often first argue that if it's a fraud conviction or a fraud offense, that the offense or conviction is a crime involving moral turpitude, which is also a term of art in immigration law. And so if you have a crime involving moral turpitude, then you have illegally procured your naturalization because you could not have established good moral character as someone who has a crime involving moral turpitude. But then obviously, even besides the CIMT issue, the government can say that the person lacked good moral character because they committed unlawful acts. There are several unlawful acts defined by regulation that preclude good moral character, and the government can point to these as well. But since different fraud statutes often have different elements or mens rea, this is where defense counsel can try to poke holes in the government's case. And so I don't know if we've talked about the good moral character period for naturalization, but that's, I think I referred to it. Basically, what that means is to establish eligibility for naturalization, you have to establish you've had good moral character, which is defined by regulation and is a term of art, from 5 years before, from the time of your application for naturalization, looking 5 years back. So if you have committed a crime or criminal offense during that period, you would be barred from naturalization. And so if the government can essentially reconstruct a record, say you have a post-naturalization conviction, but it's close in time to the person's naturalization. Well, then the government might say, let's do an investigation and see if we can find evidence of the criminal activity that formed the basis of that post-naturalization conviction prior to naturalization, but during that good moral character period. It can get a little complex, but those are also ways that defense counsel in these cases can try to pick apart the government's case, because if there's arguments about when certain things happened and the credibility of the evidence, you really want to look closely at that 5-year period and how can you poke the holes, or how can you say that the activity didn't occur then, or at least that the government hasn't shown clearly and unequivocally that the activity occurred during that 5-year period. So that's what we mean when we say reconstructing a record. And often it can be a little difficult because, like we mentioned, these cases often involve people who naturalized potentially years, decades ago, and then the criminal activity and their good moral character period was even farther ago. So, that can be difficult too, just finding the evidence to rebut the government's claims. And I'll move on to the next slide. Okay, so consequences of denaturalization. The consequences can be immediate and significant. You lose your citizenship rights, and in many cases, you are exposed to detention. And in many cases now, at least, you are exposed to detention and removal. So obviously, you lose your passport. The government, I think, often requires as part of the order that the person surrender their passport or any other documents showing citizenship to the government. You can't vote. It can impact job eligibility depending on where you work. And then the person reverts back to their status prior to naturalization, which in most cases is lawful permanent residence. And I think I never heard about cases, prior to this administration. I never heard about cases where people were denaturalized and then actually put into removal proceedings. And I definitely never heard of denaturalized people being put into detention. But that is certainly with the government's campaign to detain as many unlawfully present non-citizens as possible, as many non-citizens with potential criminal offenses as possible. That is now a very real consequence of denaturalization. It's also detention, that is a negotiation tool in the government's tool belt with these cases, because the government does try to resolve the case, or the parties often try to resolve the case before it moves into actual litigation or before the complaint is filed. And often agreements would be made under a settlement agreement. But now the government can more credibly threaten a potential denats defendant that, look, when you're denaturalized, we will detain you, we will remove you. And that is because, again, we're seeing in the last year a significant extreme uptick in detentions and removals. And so now the likelihood of post denaturalization removal proceedings is much, much higher, and especially given the government's very strict and unwavering positions that they have in immigration court. Immigration courts have been unfortunately very unforgiving to litigants in recent months, and so it's very difficult once your case gets to immigration court to avoid detention and to avoid a very swift proceeding where they seek to remove you. And so another consequence of denaturalization, not necessarily of the denaturalization order itself, but just the investigation and litigation, is that because now the denaturalization defendant is back in the spotlight in front of the government, the government probably forgot about them for years. But now that they're back in the spotlight, the government may look and say, hey, this guy actually had a post-judgment restitution order. It's pretty substantial. He hasn't paid it. And we've let it slide for years. But now that we know about this person, we can go ahead and seek to collect on that restitution order. So, for example, say that a defendant was convicted of fraud post-naturalization. The government argues the criminal activity leading to conviction occurred prior to naturalization, so during the 5-year good moral character period before applying. And so the government's argument is naturalization was illegally procured. But now what the government can also say is, we're once again aware of your conviction that came with an order of restitution, and there's nothing wrong with the order of restitution. So we're going to file an application for writ of garnishment and seek to obtain all your property and your bank accounts and your assets to satisfy that, what is often a decades-old restitution order. And obviously that garnishment can happen regardless of denaturalization. It was a valid post-judgment order, but it's likely that if it weren't for the denaturalization litigation, the government may have continued to deprioritize that person's restitution order. So overall, the most severe consequences, in my opinion, of denaturalization are the high likelihood of immediate detention and very swift removal. And because, unlike garnishment, the government cannot detain or seek removal prior to denaturalization. And that's an important point, because obviously that would mean detention and removal of a US citizen, which the government absolutely cannot do. And so, but you can imagine if most denaturalization defendants, again, if they're older, elderly, not wealthy, on a fixed income, then the stakes of detention, particularly, and removal are extremely high. And I'll move on to the next slide. So here we've set forth some of the authorities for the denaturalization process. The DOJ Justice Manual lays out the process for the litigation on the government side. And obviously there are the statutes there that lay out all the requirements for this litigation. Can move ahead. Okay. And another important note, this is also in the statute, is that children who derive citizenship automatically through a parent who naturalized will also be stripped of their citizenship. And in practice, I haven't seen this situation or heard about it, but I imagine the derivative child, who may then be an adult, but I imagine that child may be able to seek naturalization again on their own, as long as they satisfy the requirements and have no criminal activity. But that would certainly be tricky and obviously life-changing for someone who believed that they were a citizen since childhood. Nancy, I don't know if you had anything to add.
No, I think this is the big one for me, because during the first Trump administration, it was kind of understood that a couple of things that were understood when it came to DNATs, and it turns out it was policy, but the government did not take the position then that if someone was denaturalized, that, their derivative children were also deemed to have lost citizenship. We, very clearly said our position is we denaturalize the individual who committed fraud or failed to disclose whatever information they could have, but we're not going to go after derivatives. That apparently is a policy matter. And if you look at the statute, they are deemed to have lost and to lose citizenship. There is no requirement for the government to institute proceedings against that individual. So it's almost like operation by law, derivatives lose citizenship. That's a problem. It's concerning. I don't know to what extent the government intends to pursue this, or if the government will ever pursue this, but it is something to be concerned about, especially when folks are, presented with a civil denaturalization case. What do I do? It's not just, are you giving up your citizenship? It's what happens to your children, if any derive citizenship by virtue of that. Another concern too we don't think about is one of the spaces in which denaturalization has been a surprisingly hot topic is in the civil tax space. Because what is the effect of denaturalization on your taxes? People, there's obviously what happens when you relinquish status, relinquish LPR status. But, there is the question of kind of how far does it go, and what kind of tax planning, estate planning for your children and their status do you have to worry about? And, a lot of this is frankly just stuff that we don't know and will need to be litigated. But it's certainly not anything that, I'm aware of ever having been pursued as just a matter of policy or law.
And so we've mostly touched on a lot of this, but you immediately revert to an LPR, lawful permanent resident, or green card holder upon denaturalization. Detention and deportation are possible. You lose your rights and the removal risk. And so overall, what we're seeing is the government's shift in position from denaturalization as a rare remedy to the government purporting to use it as a routine enforcement tool. And the emphasis there is on purporting to, because whether the government can actually or will actually prosecute as many cases as it claims it may remains an open question, because they are not only expensive for the defendant, but they do require a significant amount of taxpayer-funded litigation resources that DOJ could use for other litigation. And so that's it for that slide.
I think, what Lindsay was just saying is really the thing I see. I've had a lot of conversations with folks about denaturalization and whether or not we should really all be worried. And my answer for the most part is no. One, the government, don't commit any crimes. If you are a naturalized citizen and you have, concerns about the accuracy of your N-400 application or your prior immigration documents, just don't commit any crimes. I mean, some of that is easier said than done, but just try to stay under the radar. I certainly think that the government is going to go after kind of the low-hanging fruit, the easy targets, folks who have financial crimes, other crimes, who they get the automatic hits on, or they're going to go after the op Janus population. That's I think at the end, by the time they had reconciled the match fingerprints, there were probably, I think, 3,000 individuals in that op Janus population that could be referred to the Department of Justice for civil denaturalization. So those are kind of the low-hanging fruits, the easy targets in terms of who and where the government can look at denaturalizing. Unfortunately, one of the concerns is, we've seen a lot of stop and pause in visa processing and asylum processing and entry and admissions for certain nationalities in certain countries. So I do think that to the extent there are certain countries that are on this administration's target list, individuals from those countries who have recently naturalized may be subject to may be the subject of some kind of effort to investigate their naturalization applications and their immigration files in general. That said, like Lindsay mentioned, it takes a tremendous amount of resources and time to do these cases in our current situation and climate where the government is getting sued left and right. And if you are someone who follows kind of the legal news and buzz, the U.S. attorney's offices are really struggling to kind of manage and handle their defensive docket. So yes, denaturalization is a priority, and the government is very proud of the fact that they have filed 40 denaturalization lawsuits in this year, which is 4 times as many as they filed in the past. But they simply don't have the resources without some kind of significant additional push and dedication of resources to pursue 100 to 200 filings a month. There's just no way in which that amount of kind of initiation of lawsuits, civil denaturalization lawsuits, is going to happen without some kind of significant increase in, resources and hiring. I will say, when you think about kind of the administration's priorities in terms of enforcing immigration, the low-hanging fruit is really kind of the easy ways to go. And when you have process and procedure and laws that are in the US code, it's going to be much harder for the government to proceed this than in situations where, you're looking at, immigrant populations with folks who are without status, who are already removable. They are entitled to some process, but certainly not the protections of, the US code in terms of all of the procedures and the steps that the government must follow when it comes to civil denaturalization. So I've gotten a lot. I think, I spent some time talking to folks about civil denaturalization, and I think my big parting words are always, it's okay. I'm certainly not really worried right now. I have definitely been through all the permutations of concern, like what happens if, someone was to denaturalize my parents and then I'm automatically denaturalized by operation of law. Do I then have to file a declaratory action to have it deemed that I am a U.S. citizen? Like, what does this all mean? I've gone through those kind of legal permutations in my head. This is a fun exercise. But for most people, I say, look, you're either living a very, lawful, peaceful existence in the United States, don't commit any crimes, you shouldn't come to the attention of the government. And 2, if you're not within that op Janus population, then you don't really have anything to worry about. Because again, the amount of resources and time that the government would have to put into finding and prosecuting each of these cases is just not something that I see it having the capacity to do at this time or at any point in the near future. Yes. I don't know if we have any questions that we can offer before we conclude. Oh, I see some.
Yeah, looks like we have 2. And I don't know, Nancy, I could read this first one for you. It's about manual file audits, which you may know more about. So they say, if I may ask a question regarding subsequent immigration filings that often trigger a manual file audit, would submitting Form I-846 as a financial joint sponsor, not the I-130 petitioner, type of filing, would that be the type of filing that triggers a manual file audit?
It could. I've actually had somebody ask me this question where they wanted to submit a joint financial sponsor for a relative who was looking to apply for residency status. And I said, yes. I mean, when you file these, the government pulls your A file. In the ordinary course of things, I would say it's not a problem. But, you know, the very first thing that we did at USCIS when we got any kind of immigration application for any kind of immigration benefit was to pull the underlying A file. So that is going to be the first thing that any USCIS adjudicator does, immigration service officer does, is pull the A file for the applicant and the A file or the beneficiary and for the sponsor. I don't know, you know, kind of for the most part, for most folks, I would say probably not a risk, probably not something you have to worry about. I assume that all, you know, most people like disclose everything that they could. But I just don't know. I think one of the hard things too is, you know, the longer you've been in the US, the more, in some ways, the longer you've been in the US and the longer you were not naturalized before you became a naturalized citizen, obviously the more opportunities the government is going to have for fraud. I tell folks who, like I believe the one inquiry that I got was from a friend of mine who was a naturalized derivative citizen. So she naturalized by virtue of her parents. And I said, there's not going to be anything in your application. I said, your A file is basically going to be copies of your parents' file and then your certificate of citizenship. You wouldn't have made any affirmative statements. I just don't know that the government has the resources to what then they're going to pull your parents' file. Again, it's a resource question. But as a lawyer, I feel like I have to advise people that there is a risk. And we just don't know kind of what the government is going to do and the extent to which they're going to go back and investigate.
Hi, Lindsay, it looks like you're muted.
I got it. Okay. The next question is not denaturalization related. It's actually detention related. And I can actually answer that question. I don't know if Danny, if you want to email me offline, just because it's not on the topic of this presentation. I do have something to say about it, and I would actually have to look up some cases and some old emails to answer it. So you can email me.
Well, I think that's all we have, unless there's any more questions.
Alrighty, perfect. That looks like that's it for questions today. This concludes today's presentation. Thank you so much, Nancy and Lindsay, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.
Thank you.
Thank you.